Welcome to LexTalks, Legal Topics Simplified, your companion for exploring the fascinating world of law.
Absolutely.
Today we're diving deep into a topic that's especially relevant for you as law students in India.
Oh, very much so.
Parliamentary privilege. Got a stack of articles and legal analyses to sift through.
Great.
I've been prepping for this deep dive, and let me tell you,
Yeah.
there's some seriously juicy stuff in here.
You're not wrong. It's a fascinating area of law
Oh, yeah.
and one that's constantly evolving.
Yeah.
It touches on fundamental questions about how our democracy functions, the balance of power between different branches of government and even individual rights versus the collective good.
Okay, so before we get into the complexities, let's start with the basics.
Sure.
What exactly parliamentary privilege? We hear the term thrown around a lot,
Right.
but what does it actually mean in practice?
So, at its core, parliamentary privilege refers to certain legal immunities and special rights that are granted to members of parliament, or MPs, as we often call them. And this isn't some unique Indian concept.
Oh, okay.
These kinds of privileges exist in many democracies, especially those that have a parliamentary system like ours, often modeled after the Westminster system.
So it's like a global parliamentary perk.
In a way, yes.
But what's the rationale behind it?
Yeah.
Why do MPs need these special protections?
Well, the main idea is to ensure that MPs can carry out their duties effectively without fear of undue interference or legal harassment. Think about it. Their job is to debate and discuss important issues,
Right.
sometimes very controversial ones, to scrutinize the government, and ultimately to make laws that shape our society.
Right, so they need to be able to speak their minds freely without worrying about getting sued for defamation every time they criticize a policy or a person.
Exactly. Freedom of speech is absolutely crucial for a functioning parliament.
Yeah.
Article 105 of the Indian Constitution explicitly recognizes this,
Okay.
stating that MPs can't be held liable for anything they say or any vote they cast within the walls of Parliament.
So within Parliament.
Right. Got it. That doesn't mean they have a free pass to say anything they want, of course.
Right.
There are rules of decorum and parliamentary procedures they have to follow.
Yeah, of course.
But the basic principle is that they should be free to express their views and participate in debates without fear of legal repercussions.
Makes sense. But freedom of speech isn't the only privilege MPs enjoy, right?
That's right.
What are some of the other key aspects of parliamentary privilege in India?
Another important one is immunity from arrest in certain cases, specifically civil cases while Parliament is in session.
Okay.
This is to prevent MPs from being harassed or detained through legal processes while they're supposed to be attending to their legislative duties. Again, this isn't a blanket immunity. It doesn't apply to criminal offenses.
So an MP can't just skip out on paying a debt or ignore a court summons just because Parliament is in session.
No, they're still accountable to the law like any other citizen, but this immunity from arrest in civil cases is meant to prevent MPs from being bogged down in legal proceedings that could prevent them from fulfilling their responsibilities to the electorate.
Okay, so freedom of speech, immunity from arrest in civil cases.
Yes.
Is there anything else that falls under this umbrella of parliamentary privilege?
Ah, yes. There's one more that's particularly interesting about the power of Parliament to punish for its contempt.
Contempt of Parliament. That sounds almost medieval.
It does have a bit of an archaic ring to it.
What did that even mean in modern India?
It means that Parliament has the authority to take action against anyone, MP or not, who obstructs its work, disrespects its authority, or undermines its dignity.
Okay.
This could involve actions like refusing to appear before a parliamentary committee, leaking confidential information, or even publishing articles or making statements that are considered to be defamatory or insulting to the House.
So they're not just talking about being rude in the chamber.
Yeah.
This contempt power has some real teeth.
It does. Parliament can impose penalties ranging from reprimands to fines to imprisonment for contempt.
Oh.
And this power is seen as essential for maintaining the authority and effectiveness of the legislature.
That's pretty serious stuff, but I imagine it also raises a lot of questions about where the line is drawn.
Absolutely.
Like, how do you balance the need for respect and order with freedom of speech and the right to criticize those in power?
You've hit on a crucial point. The power to punish for contempt is one of the most controversial aspects of parliamentary privilege, precisely because it can potentially be used to silence dissent or stifle criticism.
Right, because if you can be punished for saying something negative about Parliament, wouldn't that make people hesitant to speak out against wrongdoing or hold MPs accountable?
Exactly, and that's why this power has to be exercised very carefully and judiciously.
Yeah.
Courts have also played a role in setting limits on the scope of this power, emphasizing that it shouldn't be used to suppress legitimate criticism or to shield MPs from accountability for their actions.
It sounds like there's a lot of potential for conflict between these privileges and other important principles like individual rights and the rule of law.
Absolutely. And navigating those tensions is where it gets really interesting, especially for law students like you,
Right.
because understanding parliamentary privilege isn't just about memorizing a list of rules.
Yeah.
It's about understanding the underlying principles, the historical context, the ongoing debates, and the real-world implications for our democracy.
So it's not just about knowing what the privileges are, but also about understanding how they've been interpreted and applied in different cases and how they might evolve in the future.
Precisely. And one case that really brings all of these issues into sharp focus,
Okay.
and which is particularly relevant for law students studying in India today, is the case involving former Prime Minister P.V. Narasimha Rao and the bribery scandal that rocked his government back in the 1990s.
Okay. I remember reading about this in my constitutional law class.
Oh, good.
Wasn't there a big Supreme Court ruling that sparked a lot of controversy?
There was, but before we dive into the legal specifics,
Yeah.
let's set the stage and remind everyone about the facts of the case. This was back in 1993, and Rao's minority government was facing a no-confidence motion in Parliament.
Oh, wow.
They needed to secure enough votes to survive, and things were looking pretty precarious.
So high-stakes political drama, and what happened? Did they manage to pull it off?
They did. The government survived the no-confidence vote, but then a year later, allegations surfaced that some MPs, specifically those belonging to the Harkan Mukti Morcha party, had received bribes in exchange for voting in favor of the government.
Mhm.
It became a huge scandal.
I bet. So where does parliamentary privilege come into all of this? Were the MPs who took the bribes protected by these special immunities?
That's precisely the question that ended up before the Supreme Court.
Okay.
And in 1998, a five-judge bench delivered a ruling that, to put it mildly, sent shockwaves through the legal community and sparked a huge public debate.
Okay, I'm on the edge of my seat. What did the court decide?
The court ruled that the MPs who had accepted bribes were indeed protected by Article 105 of the Constitution.
Wow.
Specifically, the provision that grants them immunity from legal action for anything they say or do within the walls of Parliament.
Hold on. They were protected even though they took bribes. How does that make sense?
Well, the court's reasoning was that upholding the immunity of MPs, even in this instance, was crucial for preserving the separation of powers and for ensuring the smooth functioning of the legislature.
Uh-huh.
They argued that allowing the courts to scrutinize or punish MPs for their actions within Parliament would open the door to endless legal challenges and potentially paralyze the legislative process.
So they basically prioritized the idea of a strong and independent parliament over the principle of holding individuals accountable for corrupt behavior.
That's one way to interpret it, and it's precisely why this decision was so controversial.
Yeah.
Critics argued that it effectively gave MPs a free pass to engage in all sorts of shady dealings, knowing that they couldn't be held legally accountable.
It does seem like a dangerous precedent, doesn't it?
Hey.
Like, what's to stop an MP from accepting a bribe to vote a certain way if they know they're immune from prosecution?
That was the concern of many legal scholars and commentators at the time, and as you might imagine, this debate didn't just end with the 1998 ruling.
I'm guessing this wasn't the last word on the matter.
You're absolutely right. Fast forward to 2024, and a seven-judge bench of the Supreme Court decided to revisit this issue.
Wow, a larger bench taking on a previous ruling that signals just how significant this case was. So what happened? Did they uphold the 1998 decision, or did they go in a different direction?
They went in a very different direction. The 2024 bench effectively overturned the earlier verdict.
Okay, now we're talking. What did they say? Did they finally close the loophole that seemed to allow for corruption within Parliament?
They did. The seven-judge bench emphatically stated that bribe-taking can never be protected by parliamentary privilege.
Okay.
They argued that while privilege is important for protecting the integrity and independence of the legislature, it cannot be used as a shield for criminal activity.
That makes a lot more sense to me, honestly.
Mm-hmm.
So does this mean that the controversy is finally settled? Have we struck the right balance between privilege and accountability?
Well, as with most things in law, it's not quite that simple.
Right.
While the 2024 ruling clarified the issue of bribe taking, it also opened up a whole new set of questions about the scope and limits of parliamentary privilege in other contexts.
Oh, I bet. Like, where do you draw the line between a legitimate exercise of privilege and actions that should be subject to legal scrutiny?
Exactly. And that's where the debate gets really nuanced and where you, as future lawyers, will be called upon to grapple with these complex issues.
So it's not just a matter of knowing the rules, but also of understanding how to apply them in a way that upholds the spirit of the law and the principles of our democracy.
Precisely. And that's what makes the study of parliamentary privilege so fascinating and so important for anyone interested in the intersection of law, politics, and society in India.
Well, law students, looks like we've got a lot to unpack here, but before we get too deep into the weeds, let's take a step back and consider the bigger picture.
Sure.
Why should anyone, apart from legal scholars and aspiring lawyers,
Right.
care about this whole issue of parliamentary privilege?
That's a great question. And the answer is that parliamentary privilege goes to the very heart of how our democracy functions.
Uh-huh.
It shapes the relationship between the people we elect to represent us and the laws that govern our lives.
It's about the balance of power, right? Making sure that one branch of government doesn't become too dominant or abuse its authority.
Exactly. And it's also about protecting the space for free and open debate, which is essential for a healthy democracy. But as we've seen, this privilege isn't absolute. It has to be balanced against other important values like accountability, transparency, and the rule of law.
And as the Narasimha Rao case so vividly illustrates, finding that balance isn't always easy.
It's not.
It requires careful consideration of competing interests, evolving societal values, and the ever-changing landscape of our democracy.
You're absolutely right. And that's why it's so important for all of us, not just lawyers, to understand these issues and to engage in informed discussions about how to ensure that parliamentary privilege is used responsibly and ethically to serve the best interests of our nation.
Well said. And on that note, let's shift our focus to another aspect of parliamentary privilege that often generates a lot of debate.
Okay.
The question of its codification, or rather the lack thereof,
Right.
India, is somewhat unique in that we don't have a comprehensive codified set of rules
Yeah.
that explicitly spell out every single privilege enjoyed by MPs.
That's right. And this absence of a clear-cut written code has been a source of both controversy and confusion.
So if it's not all neatly laid out in a legal document, how do we even know what these privileges are? How do courts figure out where to draw the line?
Well, that's where things get a bit tricky. Article 1053 of the Constitution states that until Parliament makes a specific law defining these privileges, they'll be the same as those enjoyed by the House of Commons in the UK at the time of India's independence, along with anything established through parliamentary conventions or court rulings here.
So we're essentially borrowing from the UK's playbook, at least for now. But doesn't that create a lot of ambiguity, especially given that the UK system itself isn't fully codified?
You're spot on. This reliance on a system that's rooted in historical precedent and evolving interpretations has led to a lot of uncertainty and debate.
I can imagine it seems like it would be open to a lot of interpretation, maybe even manipulation.
You're hitting on a key point that's precisely why there have been ongoing calls to codify these privileges in India.
Uh-huh.
Having a clear written set of rules would, in theory, bring more transparency and certainty to the system, both for MPs and for the public.
It seems like a no-brainer. Why haven't we done it yet?
Well, as with most things in law and politics, there are arguments on both sides. Some argue that codification would make the system too rigid, unable to adapt to evolving circumstances.
Okay.
They say it's better to maintain some flexibility and allow for adjustments based on new challenges or interpretations.
So they prefer a more organic case-by-case approach.
Exactly. They argue that the current system, while imperfect, allows for a certain degree of adaptability that a rigid code might not. Others, however, argue that codification is essential for accountability and for preventing abuse of privilege.
Okay.
They point out that the lack of clear written rules creates a situation where MPs might not even be aware of the boundaries of their privileges, leading to potential overreach or misuse.
It's a classic debate between flexibility and certainty, isn't it?
Yeah.
Each side has valid points, but what do you think? Where do you stand on this issue of codification?
I think there are strong arguments to be made on both sides. On the one hand, I can see the value in having a clearly defined set of rules that everyone understands and can refer to. It would certainly make things less ambiguous and potentially reduce the scope for misuse or misinterpretation. On the other hand, I also recognize the concerns about creating a system that's too rigid or that might stifle the legitimate exercise of parliamentary privilege in certain situations.
So it's about finding that sweet spot, that delicate balance between clarity and flexibility.
Exactly, and that's where the real challenge lies. It's not just about writing down a list of rules, but about crafting a system that upholds the fundamental principles of parliamentary privilege while also ensuring accountability and preventing abuse.
It sounds like a tall order, but I guess that's what makes this whole area of law so fascinating and so challenging.
It certainly is.
Well, law students, it seems like you've got some potential research topics right there.
Uh,
Now, we've talked a lot about the privileges themselves,
Right.
but let's shift our focus to the limits on those privileges. Because even though MPs enjoy special protections, there must be some things they can't do even under the cloak of privilege, right?
Absolutely. And it goes back to that core principle we discussed earlier. Privileges are intended to enable the functioning of Parliament, not to put MPs above the law or to shield them from accountability for their actions.
So it's not a get-out-of-jail-free card, as they say.
Definitely not. Courts have been very clear on that point. If an MP's actions are demonstrably not connected to their legislative duties, they can't hide behind the shield of privilege.
Can you give us an example of where this distinction might come up in practice?
Sure, let's imagine a hypothetical situation. An MP makes a defamatory statement about someone,
Oh, okay.
but they don't make this statement during a parliamentary debate or in a committee meeting. Instead, they say it at a political rally or during a television interview.
Okay.
Now, because that statement isn't directly related to their work in the legislature, it wouldn't be protected by parliamentary privilege. They
Oh.
could be sued for defamation just like any other citizen.
So context really matters. It's not just about who said it,
Right.
but where and why they said it.
Exactly. The key question is whether the statement or action is genuinely connected to the MP's legislative role.
Right.
If it's not, then the privilege doesn't apply. And it's also important to remember that privilege doesn't protect MPs from criminal prosecution.
We touched on that earlier, but it's worth repeating. So if an MP commits a crime, they can't just wave their parliamentary privilege card and walk away.
Absolutely not. They are subject to the same legal process as any other citizen.
And how does this whole process work in practice? Like, if someone accuses an MP of breaching privilege or exceeding the limits of their immunity, who decides whether that's actually the case?
That's a function of Parliament itself.
Mhm.
Each House of Parliament has its own committee of privileges that is responsible for looking into these matters.
So it's like a mini court within Parliament.
In a way, yes. If someone, whether it's another MP, or journalist, or even a regular citizen, believes that their privileges have been breached, or that an MP has abused their privilege, they can file a complaint with the relevant committee of privileges.
And what happens then? Does the committee just take their word for it?
No, they conduct a proper investigation. They gather evidence, hear testimony from witnesses, and review relevant documents and precedents. Based on their findings, they then make a recommendation to the full House.
And what can happen if the House agrees with the committee and finds that someone is guilty of a breach of privilege? What are the consequences?
They have a few options. They can issue a warning or reprimand the person if it's an MP. They can suspend them from the House for a period of time. In extreme cases, they can even expel an MP from Parliament altogether.
Wow, so it's not just a slap on the wrist. There's some real teeth to these privilege rules.
Absolutely. It's a serious matter because it goes to the heart of Parliament's authority and its ability to function effectively. And that's why it's so important to have a system in place that ensures both the protection of these privileges and the accountability of those who hold them.
It sounds like we've covered a lot of ground already. As we've talked about why, the where, and the how of parliamentary privilege.
We have.
But I have a feeling there's still more to this story, right? Especially in a dynamic and evolving democracy like India,
Oh, definitely.
where things are constantly changing and new challenges are emerging all the time.
You're absolutely right. There are a number of ongoing debates and challenges surrounding parliamentary privilege in India, debates that are shaping the future of this concept and its role in our legal system.
Okay, I'm intrigued. Hit us with those big picture questions. What are some of the key issues being grappled with right now?
Well, one of the biggest and most persistent concerns is the potential for misuse of privilege. There's a worry that it could be used to shield MPs from legitimate scrutiny or to silence critics who are trying to hold them accountable.
So it's kind of like what we saw with the initial ruling in the Narasimha Rao case.
Exactly.
Privilege being used as a shield for potentially corrupt behavior.
Exactly. That case really brought this issue to the forefront. And while the Supreme Court ultimately corrected course and closed that particular loophole, it highlighted the constant tension between protecting privilege and ensuring accountability.
Right, because if privilege is seen as a tool for evading consequences or for stifling dissent, then it undermines the very principles it's meant to uphold, doesn't it?
Precisely. And that's why there's a growing emphasis on the need for greater transparency and accountability in how privilege is invoked and exercised.
Makes sense. So what are some of the other challenges facing the concept of parliamentary privilege in India today?
Another big one, and this is a perennial challenge in democracies around the world, is striking the right balance between freedom of speech within parliament and the rights of individuals outside of it.
So it's back to that balancing act we talked about earlier.
Right.
MPs need to be able to speak freely and debate controversial issues without fear of legal repercussions.
Yes.
But what happens when that speech potentially harms someone's reputation or infringes on their rights?
That's a tough question, and there's no easy answer. It requires careful consideration of the context, the intent, and the potential harm caused by the speech in question.
It's a legal and ethical minefield, isn't it?
It can be, and it's a minefield that's constantly evolving as new situations arise, and courts grapple with how to apply these principles in the real world. For instance, consider the case of Masr al-Nay. In that instance, the court grappled with whether an MP's statements made outside Parliament but relating to a parliamentary committee's proceedings were protected by privilege. It's a complex issue with no easy answers, and it highlights the challenges courts face in navigating these gray areas.
It sounds like the intersection of parliamentary privilege and freedom of speech is a particularly tricky area. What are some of the other challenges on the horizon when it comes to this concept?
One that's becoming increasingly relevant in the digital age is the role of the media and, more broadly, the dissemination of information about parliamentary proceedings.
Okay, how does the media fit into all of this?
Well, there's the question of how far the media can go in reporting on what happens in Parliament. We have the Parliamentary Proceedings, Protection of Publication Act, which grants immunity to the media for publishing fair and accurate reports of parliamentary debates. This is crucial for transparency and for keeping the public informed about what their elected representatives are doing.
So journalists can report on the debates, the discussions, the votes, all of that is protected.
Yes, but there are limits. The Act doesn't cover the publication of expunged portions of the proceedings if the Speaker of the House or the chair of a committee orders certain remarks to be removed from the official record. Those remarks are considered off-limits for publication.
So if things get a little too heated or someone says something deemed inappropriate, it can be struck from the record and the media can't report on it.
That's right, and this raises some interesting questions about balancing the public's right to know with the need to maintain order and decorum in Parliament. There's also the question of protecting the privacy and reputation of individuals who might be mentioned during debates.
It's another one of those tricky balancing acts, isn't it? Trying to ensure transparency while also recognizing that there are legitimate reasons to restrict certain information. But how does this all play out in the age of social media? What happens when an MP tweets something controversial that was said in Parliament, or when a citizen posts a video clip of a heated exchange? Do the same rules and limitations still apply?
That's a question that legal experts are still grappling with, and it's one that's going to become increasingly important as technology continues to blur the lines between traditional media and online platforms. The existing laws were written before social media even existed, so there's a lot of uncertainty about how they should be applied in the digital realm.
It sounds like the whole concept of parliamentary privilege is facing a lot of new challenges in the 21st century. As technology changes how we communicate and how information is spread, the law is struggling to keep up.
That's a great way to put it, and I think that highlights the importance of having legal professionals who are not only well-versed in the existing laws and precedents, but who are also able to think critically and creatively about how those laws should be adapted and applied in a rapidly changing world.
Speaking of those future legal professionals, I'm curious to get your take on what all of this means for our listeners, the law students who are tuning in to this episode of LexTalks. What key insights do you hope they'll take away from our discussion today?
Well, I hope they'll come away with a deeper appreciation for the complexity and nuance of parliamentary privilege. It's not just a simple set of rules that can be memorized. It's a dynamic concept that is constantly being interpreted, reinterpreted, and challenged in light of new situations and societal changes.
So it's not just about knowing the what, but also about understanding the why and the how, right?
Exactly. I hope they'll also come away with a sense of the importance of this concept for our democracy. Parliamentary privilege plays a crucial role in protecting the integrity and independence of our legislature, which is essential for a functioning democracy.
It's about ensuring that our elected representatives can do their jobs effectively without fear of undue interference or legal harassment. But as we've discussed, it's also about recognizing the limits on those privileges and the importance of balancing them against other fundamental principles like accountability, transparency, and the rule of law.
Absolutely. And I think this is where the role of lawyers becomes particularly crucial. Lawyers are the ones who are often called upon to navigate these complex issues, to interpret the law, to advocate for their clients, and to help shape the legal landscape in a way that upholds the values of our democracy.
So for all the aspiring legal eagles out there, this is a call to action. The future of parliamentary privilege, and indeed the future of our democracy, depends on your engagement, your critical thinking skills, and your commitment to justice and the rule of law.
Well said. I encourage all of you to delve deeper into this fascinating area of law, to explore the different perspectives and arguments, and to think critically about how we can ensure that parliamentary privilege is used responsibly and ethically to serve the best interests of our nation.
On that note, let's turn our attention to a specific case that really brought the complexities and controversies of parliamentary privilege into sharp focus. The case involving Subramanian Swamy and his statements about former Prime Minister Manmohan Singh. This case, which unfolded in the early 2010s, had all the elements of a legal thriller, high-profile individuals, political intrigue, and a clash of fundamental principles.
It was a case that captured the attention of the nation and sparked a fierce debate about the boundaries of free speech, the limits of parliamentary privilege, and the role of the judiciary in mediating these competing interests.
Okay, I'm hooked. Give us the rundown on this captivating case. What were the key events that led to this legal showdown?
To set the stage, we need to go back to 2012. Subramanian Swamy, a member of parliament known for his outspoken views and his penchant for courting controversy, made a series of statements alleging that former Prime Minister Manmohan Singh had engaged in corrupt practices.
And these statements were made within the walls of Parliament during a debate or a committee meeting.
That's where things get interesting. Swamy made these statements outside of Parliament at press conferences and public rallies. He argued that his statements were protected by parliamentary privilege because they were based on information he had obtained during his work as an MP, specifically his involvement in a parliamentary committee that was looking into allegations of corruption.
So he was essentially claiming that even though he made the statements outside Parliament, they were still covered by privilege because they were connected to his parliamentary duties.
Exactly, and this is where the legal battle lines were drawn. Manmohan Singh, understandably upset by these allegations, filed a defamation case against Swamy.
So we have a clash of titans, a former prime minister accusing a sitting MP of defamation with parliamentary privilege as the key point of contention.
Precisely, and this case went all the way to the Supreme Court, raising fundamental questions about the scope and limits of privilege in the context of statements made outside the legislature.
Wow, the stakes were high. So what did the Supreme Court decide? Did they side with Swamy and uphold his claim of parliamentary privilege? Or did they rule in favor of Manmohan Singh's right to protect his reputation?
The Supreme Court's ruling was nuanced and carefully considered, reflecting the complexity of the issues at stake. They acknowledged the importance of parliamentary privilege for protecting the freedom of speech and debate within the legislature, but they also emphasized that this privilege is not absolute and cannot be used to shield MPs from accountability for defamatory statements made outside Parliament.
So they essentially drew a line between statements made within the protected sphere of Parliament and those made in the public arena where different rules and standards apply.
Exactly, and this distinction is crucial for understanding the limits of parliamentary privilege. The court made it clear that MPs cannot use their privilege as a shield to make defamatory statements outside Parliament, even if those statements are related to their parliamentary work.
That makes sense. It wouldn't be fair to allow MPs to make potentially damaging accusations without any legal recourse for those who are being targeted, just because they claim those accusations are somehow connected to their parliamentary duties.
You're right. The court recognized the potential for abuse if MPs were granted immunity for all statements, regardless of where they were made, and this ruling had significant implications for how we understand the balance between parliamentary privilege and the right to reputation.
It sounds like this case really pushed the boundaries of legal interpretation and forced the courts to grapple with some thorny questions about how to apply these principles in a way that upholds both the integrity of Parliament and the rights of individuals.
You've hit the nail on the head, and it's cases like this that make the study of parliamentary privilege so fascinating and so important for aspiring lawyers. It's not just about memorizing abstract legal concepts, but about understanding how those concepts play out in real-world situations with real-world consequences.
Well, law students, I hope you're taking notes because these are the kinds of cases that will come up in your constitutional law exams and that will shape your understanding of how law and politics intersect in India.
And these cases highlight the importance of critical thinking, legal reasoning, and the ability to analyze complex factual scenarios and apply legal principles in a thoughtful and nuanced way.
Well said. Now, before we wrap up our deep dive into the world of parliamentary privilege, I want to touch on another aspect of this concept that often gets overlooked, the historical roots of these privileges and how they've evolved over time.
That's a great point. Understanding the historical context is essential for grasping the rationale behind these privileges and for appreciating how they've been shaped by political and social changes over the centuries.
So let's take a quick journey back in time. Where did these ideas about parliamentary privilege come from?
The origins of parliamentary privilege can be traced back to the struggles between the English monarchy and Parliament centuries ago. In those days, Parliament was asserting its independence from the Crown, and these privileges were seen as essential for protecting its members from royal interference or intimidation.
So it was all about establishing a separate sphere of authority for Parliament, free from the control of the monarch.
Exactly. Parliament needed its members to be able to speak freely, debate without fear, and hold the government accountable without worrying about being arrested or silenced by the king.
That makes sense, but how did those English traditions end up becoming part of the Indian legal system?
Well, as you know, India's legal system is heavily influenced by British common law, thanks to our colonial history when India gained independence. Many of those British legal principles and traditions were incorporated into our own constitution and legal framework.
Including those ancient ideas about parliamentary privilege.
Precisely, and while India has obviously developed its own unique legal and political identity, those historical roots continue to shape our understanding of parliamentary privilege to this day.
It's fascinating to see how these ideas have traveled across time and continents, adapting and evolving along the way. But I imagine that the challenges facing parliamentary privilege in India today are quite different from those faced by those early English parliaments centuries ago.
You're absolutely right. The context has changed dramatically. We live in a different world with different political systems, different technologies, and different social values.
So the question becomes, how do we adapt these age-old principles to the realities of the 21st century?
That's the million-dollar question, and it's one that legal scholars, judges, and policymakers are grappling with all the time, as we've seen throughout our discussion today. Parliamentary privilege is a dynamic concept that's constantly being tested and reshaped in light of new challenges and evolving interpretations.
It sounds like this is an area of law that's ripe for exploration and debate, with plenty of opportunities for legal minds to contribute to shaping its future.
Absolutely, and for those of you who are interested in pursuing a career in constitutional law or public policy, this is a field that offers endless intellectual stimulation and the chance to make a real impact on the future of our democracy.
Well, law students, I hope this deep dive into the world of parliamentary privilege has sparked your curiosity and given you a taste of the complex and fascinating legal issues that await you in your future careers.
It certainly has been a rich discussion, and I hope our listeners are as captivated by these issues as we are.
Yeah,
To your point, it's not just theoretical.
right.
The implications of parliamentary privilege ripple through our entire legal system.
It's like this undercurrent that influences so much of what happens in our courts, in our legislature, and even in public discourse.
Oh, absolutely.
Now, before we wrap up our deep dive,
Yes.
I want to make sure we touch on a couple of other fascinating aspects of parliamentary privilege
Okay.
that we haven't had a chance to explore in depth yet.
Right.
One is the whole concept of collective versus individual privilege.
Yes, that's a crucial distinction. So far, we've mostly been talking about the privileges that apply to individual MPs, like freedom of speech and immunity from arrest.
Right.
But there's also this idea of collective privilege,
Okay.
which refers to the rights and immunities that belong to Parliament as a whole rather than to individual members.
So it's like the difference between the rights you have as an individual citizen versus the powers and functions of the government as an institution.
Exactly. A classic example of collective privilege is the power to regulate its own internal affairs.
Okay.
Parliament has the exclusive right to determine its own rules of procedure, to punish for contempt, and to control access to its proceedings and records.
So like Parliament having its own internal legal system separate from the courts and the laws that apply to everyone else.
In a sense, yes, this autonomy is seen as essential for preserving the separation of powers and for ensuring that the legislature can function effectively without undue interference from other branches of government.
That makes sense. But this collective privilege must also have limits, right? It can't just operate in a completely unchecked manner.
Of course not. Like all exercises of power, This collective privilege must be exercised within the bounds of the Constitution and the principles of the rule of law.
Uh-uh.
Courts have the power to intervene if they find that Parliament has exceeded its authority or acted in a manner that violates fundamental rights.
So it's like a system of checks and balances,
Precisely.
where each branch of government has its own sphere of power, but is also subject to limitations and oversight from the others.
Exactly. It's all about ensuring that power is distributed and exercised responsibly without any one branch becoming too dominant or exceeding its constitutional mandate.
That's a great reminder of how these legal concepts are all interconnected
Hmm.
and how they shape the delicate balance of power within our democracy.
Ah.
Now, before we wrap up, I want to circle back to something you said earlier
Okay.
about the importance of lawyers in navigating these complex issues.
Uh,
Can you elaborate on that a bit? What specific roles do lawyers play in the world of parliamentary privilege?
Lawyers play a multifaceted role. They might advise MPs on the scope of their privileges, represent them in legal proceedings related to privilege, or even challenge the validity of certain privileges in court. They might also work for media organizations, helping them navigate the legal complexities of reporting on parliamentary proceedings.
So it's not just about working within the legislature itself, but also about understanding how these privileges intersect with other areas of law, like media law, defamation law, and even criminal law.
Absolutely, and I think that's what makes this area of law so intellectually stimulating and professionally rewarding. It touches on so many different aspects of our legal system and raises fundamental questions about the nature of democracy, freedom of speech, and the rule of law.
Well, law students, I hope this conversation has given you a taste of the excitement, the challenges that await you in the legal profession. Parliamentary privilege is just one example of the many fascinating and complex areas of law that you'll have the opportunity to explore and engage with.
I completely agree. As future lawyers, you'll have the chance to shape the legal landscape, to advocate for justice, and to contribute to the ongoing evolution of our democracy. It's a responsibility that should be embraced with enthusiasm and a commitment to upholding the highest ethical standards.
Well said. And on that inspiring note, I think it's time to wrap up this episode of Lex Talks.
Okay.
I want to thank our expert for sharing their insights and for guiding us through the intricacies of parliamentary privilege.
It's been my pleasure. These conversations are always so enriching, and I'm always impressed by the curiosity and engagement of our listeners.
And to our listeners, thank you for joining us on this deep dive into the world of law. We hope you've learned something new and that you'll continue to explore these fascinating legal topics with us.
Remember, the law is a living, breathing entity that's constantly evolving, so it's important to stay informed, stay engaged, and never stop asking questions.
Thank you for listening to Lex Talks. Follow, subscribe, and stay notified to never miss an episode.